We're joined by Christopher Davis, a partner in the Corporate and Commercial Advisory team at McGuinness Wilson. Christopher, thank you for joining us on BRR Media.
Thanks, Kate.
Now, Christopher, late last year the government released an exposure draft looking to amend the rules around the payment of company dividends. What are the key changes that the exposure draft proposes to make?
Well, for the second time in 2 years, we've seen a proposal by the government to change the rules. And there are basically three that I'd like to highlight just now. The first is that there was a solvency test introduced 2 years ago. There's a new solvency test requirement introduced into the legislation, which makes things a lot clearer. Some of the concepts that were introduced 2 years ago weren't all that helpful. The second is that there was a requirement in determining the solvency to determine net assets minus liabilities. The previous legislation said you had to use the accounting standards to do that, which for some entities that didn't have to use the accounting standards imposed a greater burden than really they needed to be. So now companies that aren't required to comply with the accounting standards, when they determine net assets, they don't have to go to the accounting standards. That's a help. The third sits around the ability for the rules to apply to situations where companies may declare dividends or resolve and determine. The previous rules didn't accommodate the two differences, declaration or resolution or determination. So there was confusion about when you had to apply the solvency test back under the old rules. So now it's much clearer for both of those situations.
And do you see any issues with the potential changes?
I do, and I think other commentators do as well. Clearly these changes were brought about by stakeholders saying to government they didn't quite get it right 2 years ago. There's still a couple of situations where these new rules probably haven't gone far enough. First is that perhaps the way in which these rules apply to wholly owned corporate groups where there might be a deed of cross guarantee in place when overall the whole group is in effect going to meet the solvency test, but there are some restrictions on applying the solvency test at each entity in a corporate chain could provide some unintended outcomes that are not desirable. And probably another unintended consequence is that even for those companies that are required to comply with accounting standards, they now, unfortunately, are still burdened with determining net assets on an accounting standards basis, which is still quite an onerous obligation before the directors want to take the step to declare a dividend. So there's still some elements of inflexibility there, which perhaps when 2 years ago they were trying to design flexibility, they still sit there and probably aren't really needed.
And just finally, what do you see as the practical effect of the changes?
I think practically we're going to see not a great deal of change from some of the larger corporates because they've been quite wary for the last couple of years since the last amendments to Section 254T of the Corporations Act. This is also particularly the case that despite the ambiguity of the previous legislation, the interactions with the tax rules have been quite burdensome and challenging for some corporates because the Commissioner of Taxation has come out with a view that because of the new expansive definition or the rules in 254T, some distributions might not be frankable by companies now under 254T. So people have been very careful to look at the Corporations Act plus the tax interactions. They've always been quite careful about dividend declarations for the last couple of years. And the way in which the GSC has affected some balance sheets and profitability and so forth, company distributions and frankability for tax purposes has been a very key issue. So people are watching this issue on being able to deal with dividends accurately and prudently very closely.
Well, some interesting insights there. Thank you, Christopher, for joining us.
Thanks, Kate.